handing you a copy of a appeals court case from the First Circuit Court of Appeals from 1980, where you petitioned the court based upon a criminal conviction of perjury. Do you recall that case?
Okay. We're not going to, excuse me. Look at me. I'm your lawyer. If I'm speaking, you don't speak. We are not going to have you litigate the other cases. This is a copyright case. I thought that you would do this because of the way that you guys litigate. So I want you to know my position is as follows, and then let's see if we can't either resolve it on the record or off the record. Under subsection C, I can terminate this deposition based on what I believe is your bad faith harassment for sufficient enough time to move and seek a protective order. Or you and I can agree without prejudice to your position that I will file a timely motion for protective order, but I will not let you go into anything that doesn't deal with either the copyright case or your defenses to the copyright case. If that's not sufficient, we'll call Judge King right now. I have the pleadings with me. If you could point me to a portion of the complaint, amended complaint, defendant's answer from the defendant's motion to dismiss, second motion to dismiss, response to the motion to dismiss, reply or order denying motion to dismiss that raises issues that allow you to interrogate this witness on a 22-year-old opinion. Please show me.
First, I believe that you need to stop with the long speaking objections. If you have a specific objection, I'm sure you can make it. Second, whether or not Mr. Katz was convicted of criminal perjury is an important issue that goes to the veracity of your client's ability to testify, because it's definitely relevant in this case. His ability to testify truthfully at today's deposition is absolutely relevant. It's important for me to know that he's going to be able to testify. Third, let me read you your own words, Mr. Kluger. Quote, "Let me see if I can educate you. Let me see if I can lay some ground rules that every court will agree. Here's the deal. You can object to form. You can object to privilege. In that case, I suggest you instruct him," quote her, "not to answer because there's an argument that the privilege would be waived. Asked and answered is a form objection. Cumulative is form objection. Speaking objections are not allowed. So you have two choices, Mr. Kluger. Make your objection, and if not, I'll press for the answer. Or if you find that I'm being abusive, you suggest that you adjourn the deposition. Are you going to adjourn this deposition based on me asking whether or not Mr. Katz is going to be able to truthfully testify in light of his criminal perjury history?"
A 1978 proceeding, even if it would go to credibility of a witness, which this wouldn't because of the nature of the civil proceeding, is clearly time barred under the federal rules as not being recent enough for you to examine. It's clear that you're doing it for harassment. If it was merely the question of have you ever been convicted of a crime and he answered it and you asked exactly the question, but you're not doing that, you're grandstanding for your client. So I am going to seek a protective order. I leave it in your court. Do you want me to adjourn the deposition for sufficient time to do that? Or you want to ask your next questions? Because we will sit here and answer the rest of your questions. We won't answer that.
Okay. So we'll make a note in the record to revisit this issue based upon Mr. Kluger's statement that he's going to file a motion for protective order on that specific topic.
Okay.
Okay. Mr. Katz, have you ever been convicted of perjury?
The question, what you call perjury?
What do you believe perjury means?
The question can be answered yes or no.
If given different answer on question number 8 is a perjury, then I did. If this is not, then I did not.
Do you know what perjury means?
I'm gonna seek a protective order. I allowed him to answer that. You know what my position is. The entire issue relating to Raanan Katz as a landlord in the Massachusetts Housing Court in 1978 will be the subject of a motion for protective order.
30 clear.
So Mr. Katz's current understanding of what perjury is for his purposes to answer questions today is not relevant? That's a yes or no question. Is it relevant
No,
for
but-
today?
But it's not my deposition, so.
Right, it's mine, yet somehow you believe that your testimony matters.
No, I'm not testifying. I'm moving him for a protective order. Ask your next line of questions. He's not answering any questions relating to a 1978.
I didn't ask him questions about a 1978 case. I asked him questions about perjury generally.
No.
That's not okay either?
Ask your next question.
Is that okay for me to ask?
It's part of this 1978 proceeding. And you know it is. Don't be a wise guy.
Don't talk down to me.